Our next speaker is Gary Silverman. He's the founder of Silverman and Theologu. His firm handles a wide range of issues in both business and commercial law. His firm is a creditor's rights and business law firm that focuses on consumer and commercial collections. Gary, I'm going to go ahead and go on mute and let you take it away. And thank you again for signing on to speak to our guests. We really appreciate what you do for us.
My pleasure, Don. Thanks so much. And I was smiling when you introduced us because I always love it when someone can say my partner's name. It's so rare people can say Theologu. For the first 3 months we worked together, I actually could not say his name. So I'm so glad that you could. You've got it down. You've introduced me a few times now. Every time you've done it, you've done great. Folks, thanks so much for joining us. I really appreciate being invited to this event. I always love speaking at MACUMA events, and I especially enjoy being invited to a virtual event since you don't know if I'm wearing pants and I don't know if you're wearing pajamas. So it's kind of unique for all of us and really wonderful. And again, I really appreciate the invite. What we're going to talk about today is bad debt collections and a few topics in that one category. Referral timeline criteria, suit ready, and I'll explain that further. Avoiding estoppel issues, we'll explain that further, and communication between lawyers and their clients. We're also going to throw a little COVID collection information at you. And then if we have time at the end, I'd like to talk about bad debt collections as it relates to replevin, death of a member, bankruptcy, and foreclosure. My partner's wife, who works for us, Diana Theologu, as many of you know, handles our bankruptcy and foreclosure section. So I can read these slides and give you a little bit of information. She would be the person to speak to it if we needed more information. And of course, the folks at our firm are always available for questions. So let me move on to the first slide. So as you see from the first slide on referral timeline, time is your enemy. As you can see what it says, set a timeline for when accounts should be referred and recovered. Statistically proven that accounts age and the likelihood of collection decrease dramatically. So basically, what we tell all of our clients is the key for us to getting referrals and to any law firm or getting referrals is timing. If you look at the chart on the right, you'll see that collections decrease to 10, 15% once these files become 150, 180 days old. We know that most of our clients are going to refer accounts from when they go bad to probably 120 to 150. We get that. We've been in the credit union world for many years now. We represent a lot of credit unions in the Mid-Atlantic and some other places as well. We get the fact that you're going to work with your members longer than, say, maybe a bank will. But we try to stress the longer you wait, the longer it goes out, and the further away it comes from the time that there's a fault, there's always going to be issues with how long it will take to collect a matter. As an example, if we get a matter that's 90 days old, and I know we never see those, but if we do, a 90-day-old account will probably be settled with a letter and a phone call. A 6-month, 9-month-old account is going to be settled with a lawsuit. It's just the way it works. So what we tell folks is as soon as you can, as fast as you can. That's really the key for us on when files are referred to us. So referring accounts. We've had some issues and we've seen some clients with issues is more what I should say. And of course, when Navy had its issue with the CFPB, how you refer accounts and the criteria you set for how you refer accounts is very important. So what you see here is a list of, depending on the type of account, credit card, automobile, HELOC, and dollar amount that you pick, let's say on a credit card over or under $5,000, how you set the criteria for what you will and won't refer or how you refer is going to be very important. So some of our credit unions, for example, will refer accounts $1,500 and under to a collection agency, $1,500 and over to a law firm. They'll refer these accounts at 4 months, 6 months, 7 months, hopefully not 9 months. They'll refer accounts that meet certain criteria as far as scoring. Many of our clients will do scoring, and when they do that scoring, they'll determine if an account meets a specific score. They'll refer those accounts. If the account doesn't meet that specific score, they will not. And again, with automobile loans, with HELOCs, it's the same thing. You need to have a specific outline and a written outline of how you refer accounts, and this should be something that you keep. The reason why we're stressing this and the reason why we mentioned CFPB litigation in this and days delinquent in this is because we've seen litigation where there are lawsuits brought for discrimination based on you referred my account, but you didn't refer that account. And so unless there's a policy in place for referring accounts, you may run into an issue where someone will look at you and say, why did you refer this account, not that account? Or you'll see an attorney who will sue you, and that attorney will say, send me all the accounts that you referred in the 30-day, 60-day, 90-day period. Let me review those and determine if these accounts were under the same criteria or met the same criteria as my client's account. If they don't, then they're going to say, well, then they're going to go on to the next question or the next issue or the next issue and question, where you're going to have to start answering some questions on your own. So suit ready, and this covers a few slides, very important when accounts are referred to attorney for collection. And the reason why I say suit ready is that when we get accounts from, and I keep saying we, but this is for any lawyer that you use, any law firm that you use. I'm sure if they were sitting in and watching this, they would all be saying, yes, that's good. Keep talking about those things. So whenever a law firm is getting an account and is looking at what they get, what we want to be sure of is we're getting information that allows us to file suit. When you send us the account, or if we're going to do a letter and a phone call, or whatever your criteria is for law firms. For us, it's usually a letter, 2 phone calls, and then lawsuit. Some law firms work differently. Some clients have different criteria. So once you get to that level of suit, when you refer an account from the beginning, or whether you're referring just some information on a spreadsheet in the beginning and then other information later on, you need to make sure that that information, again, is what we call suit ready. So if you look down the list, that that what you refer has information supporting the balance, that you can determine the interest rates, the correct attorney's fees, the accuracy of demand letter, timely filing, all of the things that you want to make sure of that we can be ready to file suit when we get a file. So some of our clients will say, well, I'll send you a spreadsheet to begin with, and then I'll send you everything else afterwards, because you may resolve some of these cases. I don't have to send you everything suit ready. There's litigation going on right now, and has been for actually a couple of years now, but it's really starting to heat up on attorneys reviewing cases and attorneys making sure that they're reviewing cases even before they send demand letters. This is something called meaningful involvement. It's a new standard. It's not in any code. It's not any law. It's mostly CFPB and now court applied. But this meaningful involvement standard means that as an attorney, when I get a case, I need to evaluate it to determine whether it's right. Have you sent me enough information for me to say, yes, this is something that I can move on? If I don't do that, if you just send, say, a spreadsheet that's got names, phone numbers, addresses, and a number on it, there's no way I can evaluate if that's correct. Potentially, you could send me an affidavit saying everything I just sent you is true and accurate. And if I see that, potentially I can move on that. But if you send files that are suit ready, that allows an attorney to evaluate what you're sending and allows us to make sure that we have the right information. So if it ever comes back to us and someone says, how do you know this was ready for suit? How do you know that this person even owed the money? We're able to say, well, the client sent me the full file. I was able to evaluate the file and make a determination that this was correct. Again, forget about the meaningful attorney involvement. It helps us and allows us to move faster if we can make sure that we have everything to begin with. We certainly have clients that don't send us everything to begin with, and I'm sure most other law firms have the same issue. And so what they end up doing is they move the file from letter to phone call to second phone call, and then when they're ready to file suit, they review their file and say, oh, I'm missing these 10 things. And then they email or whatever they do and ask the client for the missing information. What happens then is you lose 30 or 45 days emailing back and forth to find out what the correct information is, even though you may have a sheet that says what it is. And then everyone wants to make sure that everyone has what they need to move forward. And now you've lost even 60 days to go to suit, as opposed to sending a file suit ready. And once you do that, then that suit ready file can be sued after that letter and phone call process. So you're adding time and you're causing more issues for you when you're sending a file that's not suit ready, that's going to take longer and more time for us to file. And again, from the first slide, time's the enemy. Not only when you refer it, but when we file suit. To everything that we do, fast is better here. You want to make sure that we have the ability to do that. So what's suit ready? What's the specifics of suit ready? So for us, the best that we can get, everything that we can get, is member name, phone number, member's home and work cell phone number, Social Security, date of birth, employment information, credit report information, which you all have, co-signer information applicable, photocopy of driver's license and the photo ID. So you may say, why do I need to send employment information, or why do I need to send photo ID or anything like that? So I would say that suit ready means suit ready and beyond. So for our purposes, we want to make sure that we have everything that we need to move forward and beyond. So it's not about us filing a lawsuit, but it's about us being able to take a judgment, and it's being able for us to move forward on post-judgment. So in the case of sending debtor information, what you're specifically, or member information, what you're basically sending us, if you send us employment information and photocopy of a driver's license, if someone challenges, well, I didn't sign that form, that's not me, I didn't do that. With a photocopy of a member's driver's license, we have a signature on a driver's license in most cases. And we can say, here you go, let's move on to the next issue you have, or pay the debt. In the case of employment information, so security, work numbers and all of these things, once we take a judgment, instead of going back to you and saying, do you have this information? Instead of going to find this information, you all have it, it's in your files. Giving it to us or sending to us gives us the ability to then use that information once we take a judgment for the post-judgment work that we need to do, whether it's a bank attachment, a garnishment, or any other facility that's available to us. But again, time is the enemy here. I'll keep saying it. So our ability to be able to go straight forward with the information we have, as opposed to coming back to you and saying, can I please get this information? Now I need this, or now I need this. We'll do it. And we always do, and we're doing it on a regular basis. Most of the time now it's usually through email, but we're always requesting additional information. And some of you who are our clients may be nodding saying, yeah, those guys are always emailing me for additional information. This is mostly the reason why. We'll email our clients for a couple of reasons, but the two main ones are usually asking for information, whether it's for suit or post-judgment and trial, or we're calling for settlement, hopefully, and that's the best phone call. There's other reasons as well, but those are probably the main reasons we're calling and the main reasons why we're looking for additional information. All right, so on Suit Ready on documentation, you'll see a list on this slide, and you'll see a list on the next slide that gives you a bit of an outline that talks about what we need. Again, we as lawyers need to move forward. A copy of this, well, I know that there'll be some distribution on this, but if anyone wants a copy of this deck when we're done, I know that it'll be available through MACUMA, but if you want to email us to get a copy of the deck so you can see some of this information, that's fine as well. So that I don't expect people to be taking notes or memorizing this list. But in any event, what you'll see here is, again, for an auto loan where it's not a repossession and where it's a replevin or collection for us, a copy of the loan agreement, transaction history, copy of the security interest filing. The copy of what I would also say on the automobile loan is any notices that you've sent. You'll see it on the next one as well on after repossession. But on a replevin or collection, any notice you've sent, any transactional history is really very important for me to send. There's a lot of litigation going on right now around replevins. One of our clients has actually been sued 3 times on repossession issues. I think it might even be more than that now. I'm not positive. For nothing that they've done wrong. It's just there's a fantastic plaintiff's bar that's cropped up that is suing banks, credit unions, law firms, on FDCPA and other like violations. Many of them aren't even FDCPA or like violations, but they got to eat too. So they spend all their time coming up with these fun and unique lawsuits. So giving us all of the information you have in an account is going to be very important for us to determine whether or not we can move forward or whether we need to advise you that you need to either make some changes in how you do things, or on a particular file, we may need to send additional documentation before we do anything. On the automobile deficiency, this is after repossession and sale. You'll see there's more information that's required, obviously, and this also goes to the litigation that we're seeing around repossession and automobile loans. A copy of the loan agreement, transactional history, the same as above. Copy of the security interest filing, again, same as above. And then you'll see copy of all of the notices. There's a lot of litigation ongoing right now on these notices, and none of it is very good for credit unions or for banks that do car loans. These notices need to be very exacting. These notices need to be sent at very specific times. They have to have the exact and right wording. And I can honestly tell you, it's not this bad, but missing I's and missing T's and forgetting to dot the I's and cross the T's are leading to litigation now. And typically they're leading to class action lawsuits. Because again, if you've made one car loan, you've probably made a lot. If you're using one letter or one document, you've probably used it for a lot. So these lawyers are seeing dollar signs in these lawsuits because they figure if someone comes to them with bad paperwork, chances are you've given that bad paperwork to plenty of people, and they're more than happy to sue you for their client, but they're ecstatic when they can actually sue you for other people. And those class action lawsuits are really starting to come up, and we're really seeing a rise in that now. Actually, we're not seeing a rise in anything right now, thanks to the fact that the courts are barely working in COVID, but I'll get to that in a minute. Staying on suit ready and documentation for credit cards, obviously the copy of the application, terms and conditions, transaction history, statement showing last payment. That last one, statement showing last payment, is very important. The issue that we have when we file lawsuits or when we go to court to take judgment, even more importantly, is judges will constantly be asking us about the statement showing the last payment. When was the last payment made? What was the last payment? What was the principal balance due? How are you accruing the interest? Again, that's going to come from your terms and conditions. Have you accrued the interest correctly? Most of our lawsuits where we have issues are going to come from last statement and interest. If we don't have the terms and conditions, if we don't have last statement, it makes it very difficult for us and any lawyer that you use to be able to process these accounts and move them forward. Signature loans, a copy of the signed agreement, if not available, application, checks cashed, and copy of transaction history. Signature loans are usually, again, very light files because it's usually one document, cash comes out, and there's not much more to it. Overdrawn checks, again, copy of the membership agreement, statement showing the overdrawn amounts, and copy of the NSF checks, if that's what it is. These are both fairly straightforward. We don't see signature loan and overdrawn checks very much. I think mostly because the amounts are lower and they may not come to law firms. But where we do, you want to make sure that we have this information. Most of what we see are from the first two slides. The beginning of this slide on credit card and on the first slide. We use lots of fancy words in the law like estoppel so that we can, use fancy words, and that way we can charge more, I suppose. But estoppel basically is just, if you take the S part out and the P-E-L at the end, basically it's just stop. Estoppel is a requirement that if you do something once, you can't do it again, or you're stopped from doing it. So in terms of what matter to us, in terms of what matter to us for today's discussion and for us representing credit unions, you need to make sure that when you have an account and an account is delinquent, if a member has multiple accounts or a member has, in most cases, multiple debt, it's a credit card, it's a car, it's lots of things, you need to let your lawyer know. Because the last thing you want to do, and we've had this happen, is sue on a $5,000 credit card and not mention the car that may be in default or not. And for our failure to do that, what will end up happening is we may be stopped from bringing that lawsuit for the vehicle. We may not need to bring the lawsuit for the car if the car is still being paid and still being paid current, but we need to know about it. When you're referring an account, you need to either refer all these accounts are cross-collateralized. All of these accounts typically mean one default means all default, as you'll see in the first bullet here. We haven't seen any paperwork from any of our clients that's saying much different. So when you have a situation where one default equals all default, because that's what it says in your member agreements, you need to make your lawyer know, because we've had these issues, and smart lawyers defending defendants in these types of cases will say, sure, you can have your judgment for your $2,000 credit card because now I got a free car over here. And you don't want to be doing that. As you can see from everything that we've discussed, communication is key. You need to constantly communicate with us, with whoever it is your lawyer is, and keep them updated on everything that goes on in an account. I can go through the list of things that we've seen, and I don't have a lot of time for this, but I can go through the list of things that we've seen where not getting additional information has caused issues leading up to FDCPA lawsuits being filed. So pre-judgment, post-judgment, it is very important that you continue to communicate with your lawyer as to what is going on. Periodically running credit reports to update information on employment, possible assets, address information. It's only going to help us and you if you update this information to us so that when we're trying to settle, or when we're filing a lawsuit, or when we're taking a judgment, that we have this information. Very important. If someone makes a payment directly to the credit union, we need to know. The worst thing that can happen is we file a lawsuit, someone makes payments after the lawsuit is filed. We don't know those payments are made. Just using we, but it's all lawyers. And then we go and take a judgment for $10,000 when that member had paid $1,000 and the real amount owed was $9,000. Raise your hands if any of you think this is an FDCPA violation. I'm hoping all hands are raised. We've now taken a judgment against someone who didn't owe $10,000 because you forgot to tell us. It's great you're bringing those accounts down and bringing those amounts down, but we need to know. And this will come back to you just like it's on us. Make sure that you keep your attorney informed of the accounts either on a monthly basis or on a real-time basis. We like real-time. If you get a payment, let us know. If you want to let your lawyer know, once a month, that's fine. But just make sure that you don't get a payment on the first of the month. The court date is on the 20th of the month, and you tell that lawyer 10 days later you got that payment on the 1st after a judgment was taken on the 20th. I can give you lots of examples of where communication breakdown causes all sorts of issues leading up to FDCPA violations. But I'm at about my halfway mark here. I know you've got some other questions that you've got to ask through this, Paul, and I want to get to the rest of the slides. So if anyone wants to hear the horror stories of a lack of communication, feel free to catch me offline, and I'm more than happy to go through that with you. I wanted to throw a few slides in here about collections during COVID. And there are two things that I wanted to call to your attention. The first one is the HEROES Act that was recently passed by Congress. Hopefully some of you have seen the webinars our firm has done. We've done about 5 of them, I believe, over the last 5 months on COVID collections, and other credit union issues. If you haven't been able to see them, they're on our website, YouTube channel, and our firm and my personal LinkedIn page. So you really can find these things almost anywhere. One of the things that we talked about was this HEROES Act, and I wanted to call it to your attention. The reason why is not so much for what the act says. For the most part, again, it's an 1,800-page act where the Democrats propose to provide a $3 trillion influx of coronavirus relief. This new wave would include funding for state and local governments, for workers, families, for everyone. If you actually read the bill, which I did, it really is. It's railroads, it's Indian reservations. It truly is everything that they can think of, which is why I suppose it's $3 trillion. The Senate, the Senate Majority Leader and the White House don't think much of this bill. And right now, I believe, the HEALS Act is still out there. I'm not really sure how far that's going. I'm sure there'll be something coming down the pike in the next maybe 2 or 3 weeks, maybe a month when Congress is back in session, where they'll pass some legislation for additional relief. But the reason why I wanted to include this slide in here is because there's a very good chance that in January we'll have a president who's Democrat, we'll have a Senate and a House that are Democrats, and this HEROES Act could very well become law. And why it should concern all of us and why it should concern you and maybe affect how you refer collections now is that this legislation, and that's why there's the big bold part at the bottom here, this legislation enacts sweeping changes to the FDCPA. I'm just going to read this part and then discuss it. Creditors are deemed debt collectors. No debt collection is permitted until 120 days post the national emergency, and FDCPA statutory violations are increased 10x. So basically every violation goes from 1,000 to 10,000. So here's what this legislation means. So if in February we have a different looking Congress and different looking person in the presidency, then you could see this legislation become law. And what will occur then is you will see that you are now subject, you as credit unions are now subject to the FDCPA. This now means you're now debt collectors. Doesn't matter what it meant before, you are now debt collectors. You may not collect debt for 120 days past the national emergency. So whenever the president declares the national emergency is over, 4 months after that, you can start collecting your debt again. And you send the collection letter, you make a collection call, you do something that violates the FDCPA and the HEROES Act, and you won't be out $1,000, you'll be out $10,000. Now, the interesting thing about this is that there are lawyers waiting in the wings for this to become law because everyone is going to have a problem with this. Banks, credit unions, lawyers, everyone's going to have a problem with this. And normally we see letters from lawyers saying, oh, you messed up, send me $1,000. You can only imagine how happy they're going to be when they get to send letters saying, oh, you screwed up, please send me $10,000. Or you did it 10 times, please send me $100,000. It's very scary. This section of the HEROES Act is about 8 pages. It was introduced by the Banking Committee, the House Banking Committee. It's 8 pages of 1,800, but for our industry and for you as credit unions, it's a very scary 8 pages, and I wanted to call it to your attention. The next slide, rethinking the overall approach to collections during COVID. This, again, is a slide that we've had in our other events, and I wanted to throw into this as well. Because of what's going on right now, we've got pretty much collections all over the board. And what I mean by that is we have some clients who are not referring anything at all, some clients where it's business as usual, some clients telling us, don't file anything related to post-judgment right now. Please don't garnish or attach. Don't touch people's bank accounts. Basically, don't touch their paycheck if they're working. It really is all over the board. And what you need to do, and I'm not saying this is something you need to do right this very minute, because we had thought back in March when we moved our folks remote and thought that would last 2 months. And now we're in August and we're just bringing people back to the office. We understand that this thing that was supposed to last, this event that was supposed to last a couple of months, is lasting a lot longer than that. And there's some hardship out there, but then there's some other facts to consider as well. So I just want to go through these bullets and give you some things to consider. So what we've talked to a lot of our credit unions about is creating new policies to deal with members' hardships and their issues. And I know that most of you already have, but if you haven't, it's important. You know, some of our clients said to us, yeah, just keep doing what you're doing. And I don't necessarily know that's the greatest idea of all, but it's certainly their policy, and that's fine. We think that you should provide new guidance for settlement and extended payment plans. Many of our clients have said to us, if someone says I have a COVID issue, hang up the phone, tell them to speak to them in 90 to 120 days. We did that in March, and now we're extending it again. Or if not, whatever settlement works for them, do that. Some of our clients have said absolutely not. One fact to consider, and I bolded 2 of these things, is that most Americans have used their stimulus checks to pay down debt. Only 15% of the funds that people received is being used for necessity. In the Mid-Atlantic, unemployment is well below the national average at 7.5%. By the way, it's still double what it was when COVID hit. But when you look at places like California and New York and Florida, that unemployment rate is in the teens. The reason why I throw these two statistics in here is when a client says to me, we're not doing collections right now because of COVID, my answer to that is we've had record months of collections for some clients who've allowed us to do what we do, because people are using this money to pay down debt because they still have their jobs. Again, if unemployment is at 7.5%, that means 92.5% of people still have their jobs. They've gotten these extra checks. They're using the pay down debt, and not doing collections at this point isn't the smartest thing in the world. But making sure that you're working with people to deal with issues where they do have issues, and balancing between still doing what you normally do, but taking into account people have issues is really important right now. And it's why I wanted to throw this slide in. The other thing that I wanted to mention was about lawsuits. Some of our clients, as I said, have told us we're not filing lawsuits right now. And my answer to that is that's fine. But just remember, when you accumulate lawsuits for 6 months, the optics of filing this massive number of suits in 6 months from now isn't going to look good either. If the answer is, well, I don't want to file suits during a pandemic, it looks bad. Well, how bad is it going to look when you back a truck up to the courthouse and file all of these lawsuits? I'm not saying most of our clients or many of our clients are doing that, but I think you need to determine whether or not you want to file suits now because it looks bad, or whether you want to file a lot of suits later because it looks bad. And again, the potential loss of holding these suits for 6-9 months, because this is not the 3-month event we thought it was going to be. It's a lot longer, and it could go into 2021 as we're hearing predictions. So if you're holding off, when will you file? And if you don't file now, then you're just prolonging the opportunity for the inability for us to collect these accounts at some later date. So the last two bullets are really what we tell clients right now, which is think about collections, customer care, dealing with members' unemployment, and the potential arise in bankruptcy filings, which we are seeing, and then prepare for the coming wave of post-pandemic bad debt portfolio, because this will happen. This is happening. There are people that 7.5% do make up a large number, and we are going to see a lot of bad debt coming. How are you going to deal with it? Our approach to dealing with members at this point is, if they are suffering and they can't do anything, we put it off. If they can do something, then we're there to speak to them and try to work something out. And I have to say, we've done more settlements with people because our clients have been great about it, and these folks have really wanted to do it. But we've done more settlements during this pandemic than we did certainly well before the pandemic hit. So it's something to keep in mind, and something to think about as A, you're thinking about collections during the pandemic, and B, as you're thinking about collections post-pandemic. So I've got about, 15 minutes left. So I want to go through some of them, move on here. Some of the items I was going to cover if we had time. So I'll move on to those slides, and then we'll see how far we get. On the replevin, and just explaining the replevin process. Obviously, replevin's used when non-judicial repossession methods are unavailable. Basically, what that means is replevin is used, or the replevin actions that we take are used when you can't go and repossess a vehicle. So what we tell clients is, in order for us to repossess a vehicle, again, judicially, so you can't do what you need to do for a repossession. So we have to go and do it, or self-help repossession. We have to go do it through the courts. So this process gives you an example or the outline of what it is that we need to do for replevin actions. So again, it starts with us filing replevin action, and We have to have the vehicle title in order to do this. We can't even start the process without that. For us, then it becomes a show cause hearing, an issuance of a replevin, posting a bond. This is where we usually run into issues with clients because they don't want to post bonds. I have a $10,000 vehicle that's now worth $5,000 or less that I'm going to go post a $5,000 bond on? No, I don't think so. So if you're not prepared to post a bond on a repossession action, don't send it to your lawyer. You're wasting your time, you're wasting their time, and you'll just be miserable about it anyway. So just know that's coming down the pipe on everything you do on a repossession. Sheriff then goes and gets the collateral. There's a merit trial, evaluation of the collateral, and then final determination of ownership. Usually once the bond is posted and the sheriff can actually take the collateral, usually runs fairly easy after that if all of the paperwork is in order. And by that, I mean everything that you needed to do as far as notices, everything you need to do as far as paperwork, all the signatures are in order. I know that there was a time when a lot of credit unions were dealing with these third-party loans through dealerships. Some of that paperwork was not in order, and that caused a lot of issues for when we had to do the non-judicial replevins. So the judicial replevins. So you need to make sure all that paperwork is in order before you send it out. Oh, and it looks like we have a question. So I'm so happy for that. What's the effectiveness of replevin is the question I have. The effectiveness of replevin is very good if the vehicle can be, under a couple of circumstances. If you're willing to post a bond and if the vehicle can be found. If those two things work, if those two things fall into line, where you know where the car is and it's in a garage, it's in storage, it's somewhere where you know where it is, but you just can't get to it. If you know that and you're willing to post a bond, then replevin can be very effective. Sometimes what you end up finding is that once the replevin is done and the sheriff then goes to store it, then you end up with all these storage fees that someone wants to charge you and say, oh, here's $3,000 in storage fees. We've had this on multiple occasions. We've actually even had this on self-help replevins where clients try to get vehicles back. Storage fees are dictated by statute. And I know these folks like to charge whatever the heck they want to charge. And maybe they even get those numbers when they ask that information, ask for you to pay that and give you that information. But it's governed by statute. So when someone says, I need my $3,000 storage fee, you do get to say, well, you don't get that because here's what statute says on what you get. But as far as how effective they are, if you're willing to post a bond and you know where the vehicle is, then they can be very effective. And if the car has some real value, then you want to do it. If it's a $2,000 value or $3,000 value, the posting of the bond and the storage fees and everything else that comes along with that could put it out of reach and make it not make economic sense. But if you're dealing with a valuable vehicle, I think replevin can be very, very valuable. And thank you for your question. So the next slide is death of a member. And again, these last couple of slides really have nothing to do with each other than I wanted to add some slides in on some outlying issues where collections matter and someone may have questions about. So death of a member is a very interesting thing only because clients say to us, well, this guy died, now what do I do? Or this woman died, now what do I do? This member died, and what do I do next? So if you look at these three bullets that are chock full of information, and I would encourage Paul to actually take one of these bullets and make them the next question because there's so much information in there. I'm not really sure how well people are going to do on this. So it's probably an unfair question, but then you're not being graded on this, so it's not really that big a deal. When a member passes, the one thing that you can do is seize the account. You whatever money is in an account, you have a right to offset. A security interest has been created in that account, and you can do that. Now, if you look at the parens there, a word of caution, in joint accounts, the right of survivorship, surviving member does not owe the credit union money, there's no offset rights. What that basically means, and why I read it so fast is that if that member account is in two names, not just your member's name, there may be a survivor there, a wife, who owns that account as well. And in that case, you better not go seize that account. What you also may find is that the dead member also has another name on the account, a daughter, a son, and you better make sure whose money that is before you go and grab that money. There have been cases where a member has passed, or other cases where a co-owner of an account has owed a debt, but the money in the account doesn't belong to that person who owes the debt, or that person who's dead. And so you'll go and seize the account because, hey, Mr. Smith died. It's Mr. Smith's account. Yeah, his daughter's name is on it and everything, but actually it turned out to be the daughter's money, not Mr. Smith's money. We've seen cases, not a lot, but cases where the credit unions have not only have to give the money back, but they've also been hit with sanctions and punitive damages because they didn't first determine whose money it was before they seized the money. Now, this makes no sense considering what your membership agreements read. And here's what I can tell you about that. Courts simply do not care. In the event of a vehicle loan, as a secured lien holder, moving to the next bullet, credit union may repossess the vehicle and sell it. If there's an estate open, however, without an estate open, there's no way to properly send out redemption notices, no way to make a claim against deficiencies. So basically what this is saying is that if there's a vehicle and you have a security interest, you can take that vehicle if you can find that vehicle. The problem is twofold. First, if there's a deficiency, there's no way you're going to be able to notice that deficiency unless an estate is opened. And then the title cannot be transferred without an estate being open, or for a relative other person to take over the loan should they wish to do so. So you can repossess the vehicle, but you're still going to have to get some court order to be able to sell that vehicle and transfer title. So you need to be mindful of that. Oh, I have another question from the last slide. Let me finish this slide and then, actually, no, it's from the top of this slide. So let me finish this slide and then answer that question. In the event a deceased member has a loan secured by a home, foreclosure can occur without an estate being open. Let me just say that in the event there's money that's owed and it's not in an account that you can seize, and you want to go after a dead member and there isn't a relative who's going to open an estate, because most relatives are going to open an estate. They're going to want to get whatever's in that estate out of it so that that money then goes to the relatives. So chances are an estate will be open and you'll be able to get what you need from that estate. If it's an estate with no assets, you may have to do that yourself to get what you need. And I'll leave that one there. The question is, how do you determine whose money is in a joint account? Yeah, wish I knew how to do that. The courts simply don't care. Their position on it is if you saw money coming into that account from Mrs. Smith or from Mr. Smith, and then his daughter put that money in, I guess somehow you should have known that his daughter was putting the money in. There was a case out in Arizona recently. Actually, it's not that recent, but there was a case out in the Southwest recently where a daughter and a mother had money in the account. The mother put the daughter's name on the account because, for estate planning purposes. And so the daughter owed all this money. A judgment was taken against the daughter. Her name was on the account. So the credit union went and seized the funds. How would they know whose money it is? Her name was on there. That was the mother's money. It wasn't the daughter's money. The daughter's lawyer sued, and lo and behold, judgment against the credit union plus $100,000 in punitive damages. I wish I can give you an answer, and it's not even a better answer. I wish I can give you any answer on how you do this. I don't know. The other two slides on bankruptcy and foreclosure, as I mentioned, usually I save for Diana Theologu, but I'll just go through it just briefly. Collection efforts may be altered when a member files for bankruptcy protection. So when a member files, the following must be considered. And this slide on bankruptcy is fairly straightforward in that obviously everybody knows, or if everyone doesn't know, they should know, bankruptcy stops everything. Anything that you are doing, any collections you're doing, any collections we are doing is stopped by bankruptcy. Reaffirmation in 7, proof of claim filing, motion for relief. These are all actions that we can take for you, or your lawyers can take for you in getting whatever debt is owed reaffirmed. If not, filing a proof of claim. If it's a secured debt, contact your lawyer immediately for the motion for relief so you can get that secured debt back. Take a look at the bankruptcy plan. Sometimes you may not even be on that plan. If you're outside the plan and it's approved, then they still owe you that money. Discharge of debtor, always watch for that discharge to make sure once it's done, you can move forward, whether you're going to lend that person more money sometimes or see what's left over again. Potentially, maybe you weren't on the plan. On foreclosure, if you're in a second position, and I'm just going to go through the bullets, check to see if first lien is in foreclosure, demand letter acceleration, consider loss mitigation, and then refer foreclosure to an attorney and all of the information. So again, when you're looking at foreclosure, you've always got to look at the first lien if you're a second and always make a determination, A, if it's in foreclosure, and B, how much is on there. There was a time, we've been doing this for a while, there was a time when these loans were underwater and second positions were underwater as well. So those foreclosures were valueless and there really wasn't a point in us or anybody else doing that. Consider loss mitigation, modification, or forbearance. If you see a situation where you're in a second or even in a first, where you can do modification or forbearance, you want to try and do this, unless, again, there's a lot of value in the property, because with all of the fees and everything associated with those foreclosure fees, you want to make sure there's enough money to get paid. As far as referrals are concerned, you want to make sure that you refer everything suit ready, and the list is right here for that. And again, once you're done, if you don't get paid, you want to be able to pursue the deficiency balance outside of foreclosure, which is just a lawsuit. You send the deficient balance and we sue, or the dreaded 1099 that you send, which is basically, and we have a whole seminar on that you can find on our website. And the 1099 is just basically, it's the last salvo. You never paid me, but hey, here's a 1099 so you can go pay taxes on what you never paid me. It doesn't benefit you at all, but it's certainly a way to send off the debtor in a way where now they've got a tax debt and the letters don't come from you, they come from the IRS. I have one other question here, so let me take a look at that. When a beneficiary takes ownership of the deposit account upon death, do we lose the right of offset since the beneficiary doesn't owe the debt, or does the debt supersede the transfer? Now, if they take possession or ownership of the deposit account, well, they shouldn't be taking possession of or ownership of the deposit account before you have the ability to remove the money from that account. So when you find out that member has passed, you should be offsetting immediately and not worrying about who takes ownership of that account. If they take ownership of that account and come in to take the money, I would move as fast as possible to stop them from doing that, because those are funds that you are owed before they have the ability to do anything with those funds. I wanted to thank everyone for sticking it out, listening to this. For those who participated and asked a few questions, thank you so much. And if you have any questions going forward, please, our contact information is available to everyone. You can find us on our website. You can find us at the firm. And we're always available to answer any questions that you have. And we're always happy to. Don, thank you. Jeff, thank you. Paul, thank you so much. We appreciate the opportunity to be here.